Hey folks, Alex Gerstburg here, co-founder of Cover My Six, co-managing partner of Gertsburg Licata, and co-author of the Lawsuit Free Company. Written out backwards here, just for you backward reading folks. Hey, listen, a lot of folks ask me which is better. Do you want to be in a courtroom or in an arbitration? As a business lawyer, having counseled and advocated on behalf of businesses in the last 23 years, I like arbitration. And that's not a view that I share with every other business lawyer out there. There's pros and cons to it. I'm going to lay them out for you here, and you decide. One thing for sure that you need, regardless of what decision you make, is that good dispute resolution clause in your contracts with your customers, your vendors, employees, shareholders, anyone that you can have a contract with, get a contract with, and get a dispute resolution provision in there that should say where disputes are going to be resolved, how they'll be resolved, and when, what time frame, using what law. So all of those things need to go into the dispute resolution provision, and that will shorten and make more predictable the litigation process, whether it's an arbitration or a court. Okay, here's why I like arbitration better. It tends to be confidential. In court, everything is out there on public display. Anyone who goes on the clerk of court's website can see all of the nasty things that plaintiffs' lawyers say about your business, about the people there. It's not a healthy atmosphere for public discourse, okay? Everyone's mad at each other. Everyone says really nasty, emotional things. So arbitration tends to be confidential, and that is one of the biggest reasons why I like it. Also, lots of great judges on the state bench, on the federal bench, lots of judges that don't belong there, okay? There are judges on our bench who do not get elected on merit. They get elected based on party affiliation, based on what their last name is, based on how much money they could raise, based on who they know. With arbitration, you have much more control over who your decision maker is going to be, who's going to decide the merits of your case. Instead of a judge and a jury of people who know nothing about your industry and really don't care about resolving the case in the way that the parties care about resolving the case. They're there basically because if they're a juror, they got the index card in the mail for jury service. And if they're a judge, a lot of them are on the bench for the wrong reasons, frankly. Okay. Again, there's a lot of good ones, but there's a lot that you don't want handling your dispute. With arbitrators, they tend to be more industry focused, business focused, professional, and you get a lot more control and predictability over the process. That way you get to select your arbitrators from a panel of arbitrators. That's a good thing. You can strike out the ones that are not going, that you and your lawyer believe are not going to be able to handle your case fairly and equitably. So that kind of control is really important. Cost-wise, both courtrooms and arbitrations tend to cost a lot, right? I mean, the litigation just ain't cheap, which is why if you watch the video on dispute resolution clauses, avoid everything by having a notice period, a cure period, a face-to-face meeting requirement, and a mediation requirement. So all those reasons just mentioned, arbitration is better, I think, for the business. Here's the downside of arbitration. You're pretty much going to be stuck with whatever the arbitrator decides. The court decision gets to go up on appeal, sometimes on multiple appeals. That takes longer, but if you get a bum decision, you get to appeal it and get other judges to look at it and make sure that the law was correctly applied. Hopefully they correctly apply the law as well. With arbitration, it's really hard to get the arbitrator's decision overturned. It has to be really egregious, has to completely ignore the law, or there has to be fraud involved. The other thing is that arbitrators are not as beholden to the rules of evidence and the rules of precedent the way a judge is. And when a court judge is reviewed on appeal, it's those kinds of decisions that are reviewed closely. With an arbitrator, it's more loosey-goosey in terms of the application of rules of evidence and the law. So there is that counterweight in terms of predictability, but on balance, I still prefer, as the counsel for the business owner, arbitration over courtroom. They tend to be faster, they tend to be more predictable and more deliberate when it comes to who your decision maker is going to be and how they're going to decide. That's my take on it. Hope this was helpful. Thanks.